have one other matter to take, Ms. Winkles. I believe that's with you, Mr. Bopp, and Mandy Graunitz. I believe she might be the phone number that's logged in. The phone number.
Ms. Graunitz, can you hear me?
Yes, Ms. Graunitz, I can hear you. This is Commissioner Jill Carmi.
And Your Honor, just so you're aware, we tried to file with the court what we had received, so that there was some information backing us up, but the clerk would not take it. And I can understand why, and I can get to that. But just so you're aware, if Your Honor does want to see it, we tried.
Okay. Yeah, I'll just note we're on for a review hearing. We've had kind of a continuing question about Ms. Graunitz's full compliance with discovery requests. We've had multiple hearings. Essentially, I think the prior request that's continued through today is the entry of a default order for failure to comply as a sanction. We've talked about attorney fees, which are probably going to be granted no matter what we do, given the steps that Ms. Winkles and her client have had to go through to get to this place. But Ms. Winkles, I'll turn it over to you and see where we're at.
Okay, so we did file what we were asking for. And so just so Your Honor's aware, we cut down our discovery request a long time ago with the initial hearing with Judge Basher. They were only documents that we wanted produced. We did not ask for any answers, written out answers, just documentation. We have received answers to things we didn't ask. That's the only way I can explain it. We've received things about her mother, where her mother went to school, things about her college degree. We've received the photocopies of college books she's had, her syllabus from 1994. We've received the bank statements that we subpoenaed, gave to her, but with those changed, some of them pulled out. We've received no receipts. We've received copies of his work schedule, nothing about her. Essentially, what we've received, the only stuff we've received is stuff that we gave to her and back, or stuff we never asked for. But what we haven't received are the bills, the W-2s, the 1099s, the agreements, the written joint agreements, the police reports, the pleadings, the Facebook account, which is interesting because she actually contacted us and asked how to do it. We informed her, my legal assistant walked her through, never received it. Any psychological opinions, and there have been a few, schedules for 2 years, income for 2 years, public assistance, EDD stuff, which we specifically asked about. Photos, we got 5 photos, not the photos we asked for. We are told all of this existed by her. So, and on her answers, if she had said no, don't have any, fair enough. These all said reserve. And that's the whole point, is that she could have reserved them at the beginning and then tried to, come back and supplement it. No, you can't. Now is the time to answer, not to reserve. The things I need in order to put this case on, I don't have. So the only things I do have are the things that I'm able to subpoena. So I'm able to subpoena her bank statements. I have their bank statements now. I'm able to subpoena no taxes. The federal government won't let you. I'm able to subpoena none of her income, her jobs, because none of that. I can't subpoena Facebook. They won't allow you to. We tried. I can't subpoena the photos that are in her possession. The thing is, she makes statements under penalty of perjury that this is all stuff she has. What she submitted to me, I can only explain in that, for example, if I asked for a bank statement, she would send me back a spreadsheet in her own handwriting of what the bank, she's saying the bank would take, but not the original document. So I have 25 pages of writing of Ms. Graunitz to production, request for production. I don't need her stuff. That was the whole point. I have 10 pages of statements from spreadsheets that she claims are like the bank statements, but I wanted the bank statements. I have a lot of her own production. I have none of the original stuff. I have, what I can only explain is she wanted to submit something. She submitted over 20 emails to us. And of those 20 emails, none of them, well, no, one of them had at least our bank statements back in them. But of those, probably one had documents I requested, and the rest were documents nobody ever asked for. Things going really down a rabbit hole of like what she studied in college. We asked her for her degree, a copy of her degree. We got everything that ever led her up to that degree, including all her class materials. So I'm still in the same place. You know, they were initially due October 25th. They weren't received into our office until October 30th. Your Honor said, you know, October 25th. October 30th is when we got what we got. And then we sent it out again. Then they were due again by the 17th. We granted an extension till December 4th. You know, we've been in court so many times, and of the questions we asked, 38, she's produced approximately 11 of those. And of those 11, 8 of them were documents that we got by subpoena and gave to her, and she just gave back. So really, she's answered 3 out of 38, and we're still in the same boat. I have no receipts. I have no proof of what people owned at the beginning. I have no proof of anything they engaged in together. I cannot answer. You can't get a replevin when you have a CIR. I can't answer the CIR because I have no information about it, aside from self-serving statements. I have no documentation whatsoever that didn't come from my client. So I'd ask for the same thing. I'd ask for default at this point. This is a default in the replevin. So this defaults the possession only. It doesn't say who is entitled to it in the end. It only says whose possession. Now, I do want to remind Your Honor that Ms. Graunitz has said repeatedly that she's going to drop these things off at my client's house. Everything. I don't know why we're here. I'm dropping these off next weekend. They aren't there. This would make them be there. It would be a default in the replevin. So these items would go back to my client with the police. And then at that point, we still have the CIR. She wouldn't be defaulted out now. We still have to argue who is entitled to either compensation for them or the overall ownership of them at that point. But at least the possession, you know, I don't even know why to be honest, why we're here. If these things were supposed to come back so long ago, the replevin would have already been handled. So I'd ask for a default in this case. I'd ask that we get our order of replevin to have my client be able to go out with the police and get these items returned to him. The list has stayed the same since the beginning. This is a discovery sanction. She has another chance to fix this in the CIR. And I'm hopeful that she will, so that we can actually finish this once and for all. Thanks.
Thank you. Ms. Graunitz, what can you tell me? I know we had a pretty pointed talk when we were all last together about how I needed you to comply with discovery. We've had since at least August, CR 26 conferences followed by discovery motions. And it does seem as if the answer is always that you're working on it. Where are you at?
Well, good afternoon, Your Honor. I'd like to ask Your Honor's permission to listen to my position as I speak in the language I'm familiar with. I do business management, accounting, general contracting. That is the arena that I'm accustomed to, and I know it doesn't directly translate into legalese. However, in order to explain where I'm at in this case, I need to use the language I'm familiar with. If you can please just give me a second to brief you on what's been going on, then you can translate that to what position we get to take at the end, because I'm in a dilemma where I'm caught in a catch-22. So I work on the numbers, and yes, counsel admits I took an exorbitant amount of time to download each and every transaction from my bank, compile them into a spreadsheet, separate them into a budget, and send that information to her, separated deposits that I have made on all my accounts, separated potential construction materials at question. I haven't matched every client customer to each deposit yet. It's an activity that takes time. I haven't matched every receipt to the spreadsheet she's gotten, but she has a complete list of every deposit I've made, every potential item for customer materials that could be in question for improvements of the home. That satisfies the bank statement. She has all the physical accounts of my banks, and she can quickly look at the deposit amount on the bank statement and verify it with the spreadsheet I sent her to notify or verify that the information on the bank statements match exactly the information in my spreadsheet. There's a lot of information in that spreadsheet. She wants to actually take the time to review it instead of just questioning its authenticity, because the numbers should all match. He has all of the bank accounts, all of the physical statements. Today, I present a conflict of litigation agendas. I am both in the issue of returning Mr. Bopp's items to him, which takes now my personal attention, because I notified counsel about a month ago that I was liquidating storage units at Mount Brinian. We were reallocating. I've had my family move out. I've had to hire people to swap storage capabilities between assets getting sold and assets intended for long-term storage. Assets intended to get sold have been removed from Mount Brinian. And at the time I offered to return Mr. Bopp's items to him, we were discussing how important it was for me to work on these reports. So my personal time has been spent on personal reports. Thus, everything from Parkview is now grouped into a storage unit for liquidation. I personally have to go through that stuff to discern what it belonged to Mr. Bopp versus what didn't. I submitted a list of items to the person in charge, but it's up to them now to look at the items and see what was his or not. So I can either satisfy counsel's request and continuing doing discovery, or do what I proposed to do last month, which was try to go through what he had or what was in storage from construction in May and return what items I could. But we keep coming back to court, so I can't spend the time to give him back his stuff in court. So do I write reports? Do I go spend time sorting through his items? I start a customer job next on the 22nd. I'm contracted to go do 8 weeks worth of work. I won't be touching Mr. Bopp's items after that. So whatever the court decides, I don't have the capabilities of satisfying the court's request of returning his items after this weekend. This weekend is great, but I have court now Monday, so now I'm preparing for court Monday instead of trying to get his assets back to him, which is the priority. Paying counsel to block him from getting his stuff back, or allowing me the time to return his stuff and just negotiating our wage claim. That's where I'm at. I don't know. But I have court Monday, so right now he doesn't get his stuff back because I have to litigate instead. I'm frustrated. I don't want it. He wants it, but here we are litigating. How does this solve it? I don't know. I need a solution. I believe he wants his stuff back. I don't see anything that he's gaining by paying to block himself from getting his stuff back.
Yeah.
But here we are litigating, and it's cost me $60,000 in earnings potential this summer, and I'm done spending my personal time putting my clients on hold. My clients have now taken precedence. They want to give me money to go help them. I'm going to go help my clients because Mr. Bopp obviously doesn't want my help. And I don't need to spend my time on somebody who doesn't want me helping them and isn't going to pay me. Okay. So a third party can distinguish what he has on his list. I was going to offer whatever I could find, which would be a lot more on his list than whatever, because everything in our whole house got boxed up for construction in May. I don't even know what's in there. My stuff, his stuff, the kids' stuff, everybody's stuff's in storage. It's all jammed up. Nobody's benefiting from any of this litigation. I'm keeping all this stuff jammed up. But I liquidated. My business structure is back up and operational. I'm not using our assets to block my business anymore because I have to go back to work. So my clients take precedence. Mr. Bopp is choosing to litigate.
Okay.
That's where I'm at. I don't know.
Okay. All right.
What would you guys want to do about that?
Okay. No, I appreciate that input. Ms. Winkles, anything further?
Oh, hold on one second. There we go. Yes. Here's the thing is we've been told that this stuff is going to be returned for months. I mean, we've been here for months and yet it never shows up. My client has been there waiting around on weekends where we're told it's going to come, it never comes. We're told we're going to get discovery, it never comes. All of these hearings could have been accomplished. It could have been if she had sat down and got, taken the documents rather than making a spreadsheet of what the document said. She had just given me the documents. I have AI. I could have stuck it in the AI. It pops it out itself, but nobody has to do anything. 10 minutes. The fact is that we still don't have anything. As much as I would love to, base everything on what people say and trust that the spreadsheet is correct. The fact is I can't do that. That's why we asked for the documents. We're here because she hasn't done what she needs to do. This is the same for everybody. It's the same for if you have a lawyer, it's the same for if you don't. It's the same, the amount of time we spent in court, she could have gone over to the bank and she could have gone and gotten her receipts and she could have gone, to Home Depot like my client did and asked for his, his account information from them. You don't have to subpoena them. There's so much that she could have done that she hasn't. So I still ask for the writ of replevin, the order for the writ of replevin and the default, mostly default first. Because here's the thing, we're going to be waiting for her to get these things over when the police will go over there with Mr. Bob. He'll take a trailer this weekend or within 10 days, and he'll get his stuff back because the police will allow him to. They'll have an ascertainable list in the form of the complaint. It says everything that's there. We know where it's at on her property. And that's the end of this. And it should have happened a long time ago, but we were hoping, that's why I wanted them consolidated, these cases. But we are where we are because of no fault for my clients. This is Miss Graunitz making the bill go higher and higher and higher because she just doesn't want to answer. And so I'd ask Your Honor to do the default. It will have been, I'm almost somewhere around 7 times in court for discovery. And we are now, I think we served it on her months and months ago. So, this is like, so we're in December. This is like 5-6 months waiting for receipts. It's frankly ridiculous. So I'd ask Your Honor to enter the default and then immediately thereafter enter the order for the writ of replevin. And we can fight this out in the CIR, but at least that part will be done. Thank you.
Okay, so Ms. Graunitz, Ms. Winkles, here's my ruling, and it is fair to say that we have been here numerous times. I think this case was originally filed in June of 2023. I believe the amended complaint we're working off of is dated July 5th, 2023. There have been several show cause motions without really substantive responses, except a lot of the same things we're hearing today along the lines of there's just so much litigation that Ms. Graunitz can't possibly find the time to respond. I would note several CR 26 conferences have been noted by Ms. Winkles, and then discovery motions filed in this court starting in, I believe, August of 2023. I will note that at some point in time, this court did enter an order requiring pre-filing restrictions on Ms. Graunitz, just simply because of the unrelated filings that were coming in, the unrelated responses. There have been numerous orders to compel. All of this to say that it is very clear to this court that no matter what we do, pre-filing restrictions, orders to compel, attorney fee sanctions, more likely than not, Mr. Bopp is not going to get any of the discovery or responses that he is requesting. I believe more likely than not, if I don't grant the request for default, essentially as a sanction for one blatant and ongoing discovery violations, but also based on a finding that Ms. Graunitz has not materially or practically been involved in this matter in any degree that advances this case, I think we'll just keep doing this for months and months and months. So I also take into account that the nature of this cause is for replevin. I think that, as Ms. Winkle states, that does leave room for Ms. Graunitz to pursue her arguments in the CIR matter if she chooses to do so. And frankly, I also take into account that Ms. Graunitz essentially numerous times to this court has agreed and admitted that many, if not all of the items requested in the complaint for writ of replevin are Mr. Bopp's. So for all of those reasons, I am going to grant the request for an order of default. in this matter. And then once signed, Ms. Winkles certainly can decide to file for the writ of replevin should she choose to do so.
Mr. Bopp denied receiving any of his items to date, or is he going to contest that everything on this? I've returned almost everything but like $4,000 worth of stuff, Your Honor. Do they not counting that? I've spent all summer returning this stuff, not litigating over it.
Yep. So, ma'am, what I am doing, my ruling is as stands. I am for the.
He's not going to find his stuff, even if he goes to the storage unit. They lost that opportunity 2 weeks ago. It's not there anymore.
Ma'am, I'm going to go ahead and mute you if you don't let me finish. So my ruling.
Okay, well, he won't get his stuff back.
Okay. Ms. Graunitz, I have muted you. I am ending this hearing. I have made my decision. I will sign the order for default once received. Is there anything else that the parties need? I'm not, Ms. Graunitz, I will allow you to unmute, but I'm not taking further argument. I'm just asking if any party needs anything else from this court.
Not on our part, Your Honor.
Ms. Graunitz, anything else before we end this hearing?
The items are not where they would send the sheriff to get them. If they want the items back, they need my help to get them. So you can write the writ of replevin and you can send the sheriff, but it's not going to help him get his stuff back. I'm sorry. I told her this 2 weeks ago. I'm trying to get his stuff back, but it's,
okay. All right.
I need to go do it. So
Understood.
I can do it this weekend if they want to just drop court Monday, or we'll do court Monday, but I won't have any more information to the courts. I'm gone.
Okay.
This whole thing has been frustrating because I can't get my information to the court.
Understood.
I'll take in the discovery. She has all my statements. It's frustrating.
I understand, ma'am. My ruling.
Okay, so write the replevin, but he can't get his stuff back.
All right, ma'am, I have muted you again. I understand that there's nothing further that the parties need from me. My ruling is as stated. Thank you, and you are free to log off.
Thank you, Your Honor.
Thank you.